as we get going, outside of just some of the mechanics of what we'll talk about today, oftentimes what happens is families have really specific, family unique questions that you may or may not feel comfortable with sharing in the group setting. And so with that said, I encourage you to scratch my email down, my phone numbers, and if you would like to visit on a different day about a specific scenario that is unique to your family, then I certainly make myself available to you. I am honored to be a resource for you as you address some of the concerns that you have on how do we take care of our loved ones, okay? So again, if we were doing this in-house, face-to-face, that's exactly what would happen, and that is what I prefer. All right, let's see. Today's presentation is presented by Special Care. Special Care is a special needs program originated by the Mass Mutual Financial Group. And we're going to talk again about a couple of different things, that being Special Needs Trust. And then, of course, here after the end here, towards the end, we'll talk about the ABLE account. All right. Couple of disclosures. Whenever I get to this, it's always kind of funny because I tend to skim through this very quickly, but the reality of it, this is very important. You need to know that I'm just a regular guy that has sat through a couple of courses, taken a few tests. I've endured my career for 27 years, and I know a little bit about financial planning as it relates to meeting the needs of special needs families. But what I talk about today will touch on legal matters and accounting matters of which I am not legally qualified to discuss. I am sharing this with you from a Eagles perspective. And as we get kind of in the nitty gritty here, just remember that I'm just sharing with you what I have learned, but I'm not an attorney. I'm not a CPA. And then of course, there's some information about the Mass Mutual Trust Company that we'll address here after a bit. What is Special Care? It is a program developed by Mass Mutual that provides access to families regarding information and resources with dependents of any age who have a disability. It is a program that is designed to help families educate you on the opportunities and the importance and the next steps in creating a life care plan to help provide a secure financial future. Ashley, I would like to share with you that I would certainly make myself available to host an in-house presentation of variations off of what we talk about today. Because as I've done this for the last 18 months, there's just a lot that is missed that everyone I think agrees is important, but for the most part, no one can actually translate it to tangible next steps. And so if getting together would be a help, I'd make myself available to you.
Wonderful. Thank you.
Yeah. I'm trying to get let's see.
You should be able to just, there you go.
Okay. What is a chartered special needs consultant? I won't bore you with all the reading here. However, a chartered special needs consultant is a designation that is earned. There are some prerequisites. One of the prerequisites is that there's got to be several years of experience and practice in the field of addressing general financial planning needs. The Chartered Special Needs Consultant, of which I am, just says that I have taken a field of study over the last 10 years, 11 years, to help address the specific nature of helping with the life care planning and the addressing the issues of those families that have special needs in their family. And so I put my jeans on the same way as everyone else does. It's just that I have taken some time over the last several years to become uniquely qualified to address the particular issues. As a financial advisor, and I will tell you this, about 28 years ago, a guy in my Sunday school class said, "So tell me, Jeff, what do you do?" And I told him I was a financial advisor. This is what I do. And after about 30 minutes, I stopped and he said, "Okay, well, that's cool, but what do you do?" So the whole notion of being a financial advisor just says, as Ashley summarized earlier, I help my clients identify what's important to them. We create some kind of goal for that identified issue. And then we put the steps in place to reaching that goal. And the steps in place generally involve the products of an insurance product or an investment product. And so why you would use a chartered special needs consultant, it just means that you have somebody that is cognizant of the general financial planning world that is hugely important to most of us, but who has dialed it down to what does it mean to you as a caregiver of a special needs family member. And so I think it's important, but really all it does is it just tells you that somebody has taken the time to identify what is unique to that particular market. Okay, thoughts, questions, anyone? Okay. Take a snapshot of this with your phone if you have it. This is pretty comprehensive. In fact, I could spend a couple of hours going through this list, and we're not going to talk about everything in detail, but Ashley, we could do a presentation on any one of these 10 items here. Okay. So it is, let's see. Just some of the comprehensive life care planning steps. I tell families all the time, it is really important as you struggle with the minutia, and I literally call it that, and not out of disrespect, but the volume of issues that families with special needs have to address is overwhelming. It is absolutely overwhelming. I had a guy in one of the conferences that I spoke at. I mentioned one of these items, and I was walking down the aisle, mingling with the crowd, and he's shaking his head. And I asked him, I said, "Did I say something that touched a nerve?" And he said, "I lie in bed every night worried about this." And I thought, wow, that is legit. I mean, he totally stressed over. And in this particular case, he was worried about what happens if I die. Okay, well, that's a huge rock, right? But he said, "I think about this all the time." So number one says address the primary issues. So if you can, for the time being, at least for the next hour or so, try to eliminate the questions of, oh my goodness, where are we supposed to be tomorrow at 10 a.m.? We've got to schedule an appointment with Dr. So-and-so for next Tuesday. We have a treatment. We have a next step issue that is pressing in on us. In other words, if you can for a little bit, stop thinking about the minutia that has to be dealt with today and tomorrow, and begin thinking about what happens down the road here. In other words, let's identify one of the primary issues. And one of the primary issues in my perspective would be that we've got to make sure that we address the question, what happens if we're not around? I mean, literally not around. And I don't mean not around in 5 years and not around in 10 years. I mean, what if I'm not at dinner tonight? How does this impact my family? How does it directly impact the life of the individual that I am planning for? Because that's where the rubber meets the road. What is actually going to happen? Okay. I'll share with you that I have a family member that's not very well right now. In fact, he's pretty sick. And my sister-in-law shared with me the other day, said, "You know what? No one has stopped to ask Jim, can he hear?" Well, my brother wears hearing aids, and I do too, by the way. But they have taken his hearing aids out of his ears, and they don't know at shift change that my brother can't hear them, right? And then on top of that, no one is recharging his phone. So when he does get a chance to contact anybody, the phone may or may not be charged up for use. And so I go, wow, that is real. So when I ask you to address a primary issue, I mean, one of the primary issues, in fact, the number one primary issue, which is what today is all about, is what happens if I don't come home tonight? Okay. And I say that for the sole purpose of becoming very narrow-minded about how do I solve that issue. Because as sure as shooting, when we say goodnight and goodbye this afternoon, there'll be 25 other things that will hit you head on. And I totally appreciate that. But if today is going to make any difference to you in your life for the benefit of your loved one, then I really encourage you to find some time to identify specifically what you can do today to make a difference in the long-term planning of your loved one. Create a life care plan vision. In other words, this is what I have hopes for my loved one. This is what I hope will happen. And as desperate as that may be, there is some level of what you hope tomorrow will be. And I encourage you to find a way to create a vision for what you would like for your loved one. Guardianship, number 3, guardianship, alternatives to guardianship. Holy cow, we could spend 2 days on guardianship. And I will tell you that that is one of the most emotional issues that my families have to work through. And just so that you understand, my role with you, if that were to ever happen, would be to sit with you in the presence of an attorney and have these legal conversations. But I will tell you that from a court's perspective, a court is not very willing to sever someone's ability to answer for themselves. There are obviously very clear examples of when an individual cannot advocate for themselves and needs someone else to do so. But severing that relationship between that person's individual rights to answer for him or herself and identifying someone else to do that, that's a very tough conversation to have. And by the way, there are alternatives to the all or none. And that's, again, another day. Identify financial resources, prepare life care plan costs, prepare a letter of intent. We're going to talk about that in just a few minutes. Simply put, a letter of intent is a book of instructions. So a letter of intent is a notepad that says, this is what Michael's favorite food is. This is Michael's primary care physician. This is Michael's routine. I worked a lot with families that have children with autism. And so you can imagine the value of having a routine, okay? So a letter of intent says, I want somebody to have the book of life on my child if I don't come home for dinner tonight. Well, what would be in that book of life? His favorite cartoon, what time we have a snack, who his physician is, how often we go to the zoo, and it's from A to Z. And so it's this living, breathing document that someone can say literally, okay, I've got his social security number. I know his physician's name, phone number. I know the medications and whatever it may be. So when I say it's a living, breathing document, it truly is, because it's always changing. But it should be something that somebody should have available in the event that you're not around. I sat with an elderly man yesterday in his office. He's a pathologist. He's 73 years old. He's going strong. And he said, Jeff, this may sound kind of morbid, but I've started to put together a document for my wife so that if I die, she knows where all of our stuff is. And I go, yay, way to go. That's exactly what you want to do, because we love these people, right? We don't want to leave them in the lurch. And so preparing a letter of intent is one way to make sure that they don't have questions, especially with regards to the people that you care about. Preparing legal instruments goes without saying, that's hugely important. We'll talk about wills, number 8. Today, we're going to talk about special needs trust and able account. Holding a family meeting. as a life care planning step. You know why this is important? It's important because families oftentimes make the assumption, especially a mom or a dad, will make the assumption that this is what will happen if I'm not in the picture. One of the unique dynamics that happens a lot is we have siblings who say, Mom, Dad, I'll step up and I'll take care of my brother. I'll step up and I'll take care of my sister. I'll step up and I will replace you when you're no longer around. And oftentimes mom and dad or primary caregiver says, no, I don't want that for you. Son says, no, Mom, I don't mind. I really don't. But he's saying that at 17, he's saying that at 22, he's saying that at 25. And mom and dad are saying the burden of responsibility, of care, is more overwhelming than you know. And I don't want that to deter you from living your life. And so a family meeting is what happens where all of those things are ironed out. And how many people raise their hand in a group of 10 when I say who's had a family meeting? About 2 out of 10. So as important as that is, they acknowledge that it's important, but it's very seldom done. And I say do so that people kind of know what everybody's hoping to have happen. And then of course, review the life care plan annually. Questions, thoughts? Good. Why would we create a special needs trust? Well, you have a child or someone you're giving care to who has a developmental disability, who has a cognitive, congenital disability, has a brain, spinal cord injury, may have come about as a result of a medical malpractice, a personal injury, or some kind of structured settlement. They've received some recompense for something that has taken place in their life. They have assets that are in their name. And one of the reasons that we'll talk through very clearly in a minute is that a special needs trust kind of helps make sure that we don't avoid or we don't terminate or damage the public assistance that is available to them. All right. Before we do that, let's talk about, let's talk about a trust, okay? And I'm sorry I don't have a slide on this, but I really want to start at ground level here. A trust is an often used word that people kind of throw around, but a trust is an agreement and an account and a set of instructions that says this is what we want and where our stuff to go in the event that I'm not in the picture. Okay, so I have 2 children. All right, I have 5, but 2 of them are mine, and I have children that do not have special needs. So before Davis and Bailey were 18, I had a trust, and the trust account at Frost Bank or Broadway Bank or Jordanton Bank or wherever you bank, a trust account just says that my savings account, my checking account, my life insurance, my IRAs, anything that I have accumulated that has any value, the trust would become the owner on those assets. And the trust has, does anyone know who runs a trust? A trustee. Okay, so you have a trust and you have a trustee, and a trustee is a person or an organization, but it's somebody that is managing the account for the benefit of the children that are under the age of 18. Okay, so for instance, if I had life insurance and I died, I can't leave my life insurance for $500,000 to a 16-year-old boy. Okay, he would like that. That ain't gonna happen, right? I'm not even sure that I want to leave it to a 22-year-old or 25-year-old, but under the age of 18, your children can't go to the bank and open up an account. They just can't. The mechanism isn't set for children under the age of 18. So The money, though, then goes to a trust. I die, life insurance goes into the trust, and the trustee has a list of instructions, okay? And the list of instructions says that at Davis's age 21, we will pay 50% of his college education costs, and we will pay 100% if he graduates before the age of 30, right? And the trust document literally gives the instructions on how these assets are to be distributed for the benefit of a child that's under the age of 18, okay? So we have trust, we have a trustee. The trust will hold assets, okay? Cash, you could put your home in the trust, and I don't mean literally, but you assign the trust as the owner of the house. And it manages those assets for the benefit of an underage child, okay? That's how trusts generally work. Okay, well, what's a special needs trust? A special needs trust is a trust that does exactly the same thing, but for the benefit of an individual that has a disability or is incapable of managing their financial affairs, okay? And the reason that a special needs trust is different than a traditional trust is because the special needs trust has language in it that prevents the beneficiary, the child, or the special needs individual in this case, from receiving too much to the extent that it disqualifies him from public assistance. All right. So a lot of information there. Stay with me, okay? Questions, by the way, anything?
Jeffrey, a trust or special needs trust, can they be built or created after the age of 18?
Sure, it absolutely can. There's no age, there's no age constraint on when a trust can be created and when a trust can be funded for that individual before age 18 or after 18. The reason that you don't need a trust, a normal trust, for a child who is typical, right, without any cognitive or any other disability, is because after the age of 18, that person can advocate and represent himself before a court and can open up an account. Okay. So that's the only reason why. And by the way, I could still have a trust for my adult children in the event that I just don't want to give it to them now. Okay. Does that make sense?
Yes. I have a question. How do you choose the trustee?
That's a great question. That's an excellent question. I had a lady ask me one time if I would be her trustee. And fortunately, because of my investment licensing, there is a conflict of interest that legally kept me from being able to say yes. I then subsequently learned that the role of a trustee is very difficult. So how do you choose that? In a special needs case, here is my recommendation. And this is just boots on the ground, frontline experience that I would recommend you follow. And that is, you have co-trustees. You have a family member that knows who the beneficiary, and the beneficiary, just by definition, is the individual who is to receive these proceeds. Does that make sense? In other words, the
Yeah.
beneficiary would be your special needs child.
Yeah.
All right. So we have a trustee that might be a family member, a brother, a sister, a mother, a father, who is intimately aware of the beneficiary's needs. Okay. And you couple that trustee with a corporate trustee. So you have two trustees. The family member trustee is informing the corporate trustee, who might be Mark Smith at Broadway Bank, okay? And his sole purpose is to help manage the assets within the trust. He files taxes for the benefit of the trust, and does all the IRS filings, okay? So you have an individual who's intimately involved in the family, and then you have a corporate trustee. That's been the best scenario because the role of a trustee is a lot harder than just writing a check out for the purchase of a special needs vehicle. It's much more complicated than that. So that's what I have seen work in the past. Does that answer your question?
It answers my question, but this corporate person, I mean, do they follow a certain guideline that or instruction? I mean, how are we going to trust someone that we don't even know to be a trustee?
That's a great question. The trust document is literally the guideline by which the trustees are obligated by law to oblige by, right? Which is sometimes what is what keeps the family member from misappropriating funds inside the trust. I've seen situations where a family member who is a trustee, when somebody called their hand on it and the court got involved, there were assets being used out of the trust for the benefit of the child to benefit the life of the trustee, the family member trustee. And strangely enough, it came when there were multiple home improvements being done under the guise of being available for the beneficiary if and when the beneficiary ever were to come over. In other words, they had a very, very expensive driveway built on a large piece of property, and that was a misappropriation of the funds inside the trust. So it's a great question. I think that's why you actually interview a corporate trustee, and you interview that corporate trustee along with the individual who will be the family member representative. But outside of that, you're right. You just hope and pray that you found the right person, and you hope and pray that you found the right corporate. The corporate trustee, trust me, has a whole lot more to lose from a reputation perspective than an individual. An individual can really kind of hide underneath the radar, so to speak. And unless somebody calls them on the carpet, there's a lot of misappropriations that can happen.
So they kind of keep each other in check. And does the corporate trustee get a fee out of the trust? Like
They do.
Okay.
They do. And I can't tell you what the cost is, but it's usually a percentage of the assets inside the trust, but you bet they get paid for that. And by the way, as the trust is being created, you can designate that some of the costs or some of the fees of managing that trust can also be paid to the family member, right? That doesn't often happen, but if you realize, wow, it's going to cost us 3% per year to pay the bank to manage the assets in this trust, or this trust organization to manage these assets, wouldn't we also want to pay Uncle Earl,
Yeah.
$1,200 a year to, just as a gesture of goodwill? But yeah, it's right. There is a cost, certainly on the corporate side, not necessarily on the family side, unless you want it to be.
Okay. Thank you.
Yeah, great question. Two types of benefits, and I'm going to kind of pick up the pace here. We have pension, we have Social Security, disability insurance, SSDI, and we have Medicare. That's needs based on a person's financial assets that fall underneath. I say needs based, falls under the pension insurance type, and that's usually associated with someone's work history. Then we have needs-based types such as SSI and Medicaid. And the reason I bring that up here is because bullet point number 1, individuals with special needs who may qualify for both Medicaid and SSI may not receive these government benefits if their assets exceed $2,000. So listen to what I say before you check out, because this is really important. There are assets inside the trust, and usually the easiest thing to do is to fund a trust with life insurance proceeds, okay? And I'll explain that a little deeper here in a few minutes. If we if the disabled individual has a savings account, has a checking account in their name, is the recipient of Aunt Hazel's IRA, and any of those things or a combination of those things exceed $2,000, then Uncle Sam says, wait a minute, until you spend that down, we're not going to give you public assistance because it appears as though you have assets that you can use to take care of yourself. So in a nutshell, what Medicaid is it is government assistance, right? When one has spent down their estate below 2,000. So a special needs trust is a document that says we will not disqualify the client from, or the beneficiary from, public assistance, because we're going to use those assets inside the trust to purchase needed additional supplemental things that do not fall inside that $2,000 limit. Okay. So for instance, if $500,000 goes into a special needs trust and Aunt Hazel and Broadway Bank are challenged with the opportunity to meet the supplemental needs of the beneficiary, they would never give money to the beneficiary. Okay. You would never give money to the beneficiary to the extent that it would exceed $2,000 being in that person's name. Does that make sense? Stay with me, because the funds inside of a special needs trust can purchase tons of things, including vehicles, homes, vacations, etc. There's a whole list, and I won't go through the list, look it up. But there's a lot of things that you can supplement the care of your loved one that are being supplemental that do not fall within that $2,000 limit. But that's why I ran into a lady one time and she said her mother had 4 IRAs. And in each IRA, she had named her 2 children, 2 boys, both of which had special needs. She had named 2 IRAs beneficiary as one of the grandsons, and 2 IRAs beneficiary was the other grandson. And I said, no, don't do that, because if grandmother dies and these IRAs fall into the lap of these children, all of a sudden special needs, public assistance stops, and it literally stops until those assets are spent down. Okay, so individuals with special needs who have both Medicaid and SSI may not receive government benefits if their assets exceed 2,000. That's why we put the assets inside the trust, and the trustee distributes them in accordance with the language of the special needs trust. You with me? Okay, that's a lot of information there, but it is the tenet upon which the special needs trust is defined as. Okay. A strategy: place assets, including inheritance, gifts, life insurance, etc., in a carefully drafted special needs trust. A special needs trust assets that supplement the needs of your dependent and will not jeopardize a beneficiary's eligibility for needs-based government assistance such as Medicaid and SSI. You should work with an attorney that is familiar. I will just say right there, that last bullet point is, don't hire your nephew who's just out of law school, who's doing corporate law, to do this. You need a special needs attorney. And unfortunately, that costs money, but you have to do it, and you have to do it right. This is just the legalese, key law to discuss with your attorney. Auburn 93 is literally just about special needs trust. This is what, so a minute ago, I mentioned that you have to spend down your estate. Okay, let me give you a real personal experience. All right, my mother died of complications from Alzheimer's many years ago. Okay, and I am one of 5 children. I'm the best looking one for sure, no doubt. And don't do any research, just trust me on this. But I am the most handsome son she has. And But she has 5 children. Fortunately, they were able to chip in and fund, you with me? Fund the cost of long-term care. All right. So there was a nursing home that she finally ended up in. Before she moved there, she was in a Medicaid facility. I walk in one day, and she's in Lubbock, Texas. I walk in one day, and there's my mother sitting in the corner, and she's got, do y'all remember the little cups of ice cream that have a little flat wooden spoon? You know what you remember? And I think Bluebell still makes them, but there was the flat little wooden spoon. I say it's a spoon. And she was sitting over there in the corner, and she had this wooden spoon, if you will, but she had no ice cream, and she was kind of dipping it, hitting her spoon on the table that she was sitting at. And I thought, well, that's terribly sad. There's my mother. They've given her a spoon. She has no ice cream. And I asked the lady, I said, can you tell me why my mother doesn't have any ice cream? And she said, oh, you mean Nellie? And I said, well, that's not her name. It's Nell. It's not Nellie. And the Medicaid's provided care for my mother was not good enough for the 5 of us. All right. It's just a personal testimony. I'm not dissing it. I'm just telling you that for what we wanted. So all 5 of us chipped in to pay for the cost of care at a nursing home facility for my mother. All right. And we got her out of that facility. But before she could even qualify for the nursing home with the Medicaid services provided, we had to sell down her estate. We literally had a garage sale to sell her stuff, right? We had to distribute assets, right? And we had to get her estate below $2,000. Now, by the way, $2,000, I'll take it in a heartbeat. But my point is $2,000 is not a lot of money, not for an elderly mother of 5, okay? But we had to get her estate down to $2,000 before the government said, now we will help you. Okay, so ABRA 93 just says it limits the ability of individuals to transfer assets to other people in order to qualify for Medicaid. So you can't give away your stuff. There is what's called a look back period. So if your estate is worth $50,000, right? You can't give it away to get below the $2,000 threshold. You have, I think it's like a 5-year look back period. So that's just kind of minutia that's interesting to know. But you got to be real mindful of the fact that if we're going to do a special needs trust, that we got to get the beneficiary's estate down below $2,000. Special needs trust, a means of enhancing an individual's quality of life beyond the basic care. I heard somebody say one time that public assistance was an eats and sheets. Are you hearing me? EATS and sheets, SHEETS. And as that was hard to hear, but the point is that the value of a special needs trust is to exceed the basic level of care that the government is providing for our loved ones, okay? And so when you go, well, I really don't know that I have the need for a special needs trust, I go, well, you might later on discover that you want to give your loved one more than they're getting by way of public assistance, and that is sometimes described as just eats and sheets. Again, we're just trying to provide for the loved ones after our passing, and to a degree that we want to make sure happens. Bullet point 3, if properly drafted, proceeds will not affect government benefits or funds are being used, distributed by a trust, provides for your loved ones after your passing. It manages money and safeguards funds against predators and creditors, okay? A trust is a special needs trust, right? It has language on how to distribute the asset, right? And the goal is to not exceed what? We don't want to distribute anything that exceeds $2,000 directly to the beneficiary, but we can buy a whole lot of things, but we just can't give them the money to go buy it themselves. Okay. Well, that's obviously the case in a lot of cases where the beneficiary is not capable of representing themselves. All right. So the trust does that. It does a great job of distributing the money, but the trust also has a responsibility in managing the money. Okay. And that is partly what my role is, a financial advisor. So if we have assets that we want to name or move to the trust at your passing, well, if those are investments, if those are properties, if they're life insurance proceeds, well, what's happening to the money while it's just sitting there? Well, we want that money to grow, right? Because if we're taking out $25,000 a year, wouldn't it be wonderful if we had 25,000 coming in, right? So the investment return within the trust account would be awesome if the spigot opening of money going out is only large enough to or is not draining the tank too fast for money that's also coming in. Okay. So there is some role in the management of the money inside the account. Question? All right. Who should establish a special needs trust? Caregivers or donors? A third-party trust for a child, sibling, spouse, or anyone who's disabled. Let's talk about two different kinds of trust. And really, there's not really two different kinds of trust. It's all about how the trust is funded. Oh, by the way, let me just make sure that you hear this too. I'm so sorry this is going long. I'll pick up the pace. Ashley, tell me if you would pick it up or slow it down. But a third-party trust is a trust that is funded with a third party's money on behalf of an individual with a disability. Okay, a third party. So think of the beneficiary. I'm going to name Tommy as the beneficiary. Okay. If Tommy has a third party special needs trust, that trust is funded with the third party's money. Okay. So Tommy's mother is Mary. Mary has a life insurance policy on her name. Okay. When Mary dies, she, by the way, is the third party. When Mary dies, life insurance money goes into the trust for the benefit of Tommy. Okay. So the money that is to be used for Tommy's supplemental care is coming from a third party. It's not coming from Tommy. It's coming from Tommy's mother, right? And usually that comes in the form of gifts. It might come in the form of a lump sum distribution. And most times it comes in the form of life insurance proceeds. Okay. And Tommy has nothing to do with the money. He didn't earn it. He's just the recipient of those proceeds because he's the beneficiary of the third party trust. Okay. This will make sense. Now let's compare it to a first party trust, or what's called a self-settled trust. A trust funded with the beneficiary's own money, which typically is through personal injury settlements, SSI payback, inheritance, or personal savings. So Tommy was injured in a military accident. He's got head, brain, spinal, back, neck injuries that came up results as an adult. So, but prior to his disability, he had a 401k, he had a pension plan, he had savings, he had an IRA, he had life insurance. A first party trust would be funded with the assets of the actual beneficiary. Okay. So the first party trust is generally funded with a personal injury settlement. That's where we've seen first party trusts show up more often. Most times, most trusts are what we call a third party trust. And again, keep in mind, nothing has changed with regard to what a trust is, what a special needs trust is. What we're talking about is, how do we fund the trust? Do we fund it with money coming from the outside, or do we fund it with the money that's coming as a result of the beneficiary's efforts? And that might even be just a settlement, okay? Here's what happens. I have a seminar, people come, we feed them cookies and lemonade, and they get all this information, and they're all so gung-ho about going to get a trust. In fact, one of the early conversations that Ashley and I had months ago when we were talking about this day, I shared this very point, and I said, people get all excited about having a trust, right? We have directions on how assets are being distributed for the benefit of Tommy. Okay. Yay, we have a trust. Jeff, I need to meet an attorney. We got to sit down, and I want to get this trust done. Right. And I say, okay, what are we putting in the trust? What are we literally putting in the trust? And they go, I don't know, but we've got a trust. And I go, all right, you have a brand new refrigerator, but you have nothing in the refrigerator. So it serves no purpose, right? So I go, stop, forget the trust. Let's identify the assets that you have, or the assets you want, or the assets that we can create to put into the trust, right? Because haven't we talked about at length how the trust manages the distributions of assets from that account? Okay, well, it does a great job of that. Well, we need to identify, how do we fund the trust for the benefit of the beneficiary? All right. So that's if there was any one thing you should leave today with, and that is, wow, I need a trust. However, Jeff says, what am I going to put into the trust? And it can be anything of value, right? And I know that's a little confusing when you go, I can put my house in a trust. Well, what you do is you name the trust as the recipient of this asset in a will or some other legal document.
So Jeff, would you then need to create the trust to be able to name that in the will, or
Yeah,
for a beneficiary?
Yeah, you normally what you do is you have a will, and a will just says, my bicycle goes to Dawn on the day I die. Okay. And inside the will, either inside literally the language of the will in the stapled sheets of paper, or a separate document, which could be the trust. So you have your trust either inside your will, or a trust that is activated by the dynamics of the will. But that's how that would work. Did I answer? Ask me your question again.
I was just asking if you would need to set up the trust prior to, because you were talking about having an empty trust.
Yeah.
Have a trust set up prior to the passing of the person that is leaving the beneficiary.
Right. Normally what happens, you walk in and you say, I need a trust, and the attorney's going to go, that's cool. Do you have a will? And you're going to go, well, I don't have a will. And he's going to say, well, we need to get a will, right, to handle all the distribution of everything and what your desire is. And then we'll set up a trust to handle the assets. So yeah, that's kind of how that works. So normally one does not happen without the other.
Okay.
Okay.
I have a question. Like, you talked about the trust, also wanting to replace some of the money that's going out, and that's like a person like you, on a financial advisor would I guess put in their 2 cents on how to grow the money, right?
Yes.
So are those all real safe ways to, safe investments? I mean, or do you stand to like lose your money because the investor, went crazy
Right.
or something?
Man, I need you to come with me to every seminar I give, okay? Because that's an excellent question. The answer to your question is that the risk tolerance, if you will, is hugely dependent on what you want this money to do. Okay. Now, If you come to me and say, Jeff, we would like to buy a house in 5 years, and here's $10,000 and $500 a month, right? And you say, Jeff, we have 5 years, then we will build a model based on your risk tolerance level, which is defined as how do you stomach risk, right? I have money in the market and it makes me nervous and I can't sleep. And well, that tells me an awful lot. Wow. Okay. So there's not a lot of risk tolerance there, right? So, but if you say I have $10,000 and $500 a month or $50 a month, and I really don't have any design for this money, and yeah, I think we have everything taken care of it. So we have like a 10 or 15 or 20-year time frame. Well, then the options of investment become much greater because we have time for the market to do its deal, knowing that over time, generally from start to finish, the market generally does better, right? But when you shorten the time, I literally had a guy one time on like the third day of my practice 28 years ago say, I'm going to give you $100,000 and we're going to look at it in a year. Well, I'm thinking, wow, he's going to give me $100,000 and I'm going to make about $800 to feed my family off of that. And well, wait a minute, he's giving me 1 year. Well, shoot, think about it. When COVID started, the market just tanked. And for about a year, we didn't know a whole lot, right? So the more time you have. So back to your question, money that is being managed inside of a trust, right? Well, we generally say, what is the life expectancy of the beneficiary? Well, anyone who's in special needs community world knows we don't really know what the life expectancy is. I mean, we have averages, but depending upon what that concern may be, we might have a life expectancy for 10 years, or we might be around until 65, depending on what that particular issue may be. So generally there is time, but we also don't have, and this is my own personal recommendation, we don't have a lot of room to be wrong. So let's be a lot more conservative. And I just tell you, we may miss some of the growth opportunity, but we're really not worried about growth. We just don't want to lose what we have. So if the spigot is open, taking out 6% of the total bucket per year, we kind of want to earn 6%. Well, that's not too hard to do over time. So you understand what I'm saying? 6% is what's coming out of the hose. Well, we got to fill it up at the top with about 6% so that we don't lose our principal. So that's a really conservative approach to managing assets within the trust. I've only had one family over a long time say, no, let's go for it. Let's live a little. Oh, okay. All right. I mean, because it's your money, but my counsel to you is let's be cognizant of the fact that we want this money to be around a long time. Does
So
that
I
answer?
just want to stop. Oh, sorry.
Oh, I'm sorry.
No, go ahead. Go ahead.
So I was just gonna say, you're under the person that's gonna maybe invest the money is under an obligation to not go out of control with it, right? To stay within
Sure.
bounds that you set up beforehand.
And I would recommend to you specifically, and whoever's hearing this, a relationship with an advisor who has relative control over these assets does not, one, have discretionary authority. Write that down somewhere. Does not have discretionary authority. In other words, I don't call Ashley on Tuesday and say, hey, wanted you to know on Monday, we just sold off 25% of your portfolio because we think this is what you need to do. Now,
Okay.
Ashley may say, well, Jeff, I wouldn't know if that's good or not. Well, that may be the case, but I want you to know before we do anything that you have to give authority, right? And consent And I will tell my clients, well, that sounds cool. Let's do that. Would you do me a favor and send me an email saying, Jeff, per our conversation, let's move forward with the reallocation of our portfolio to represent blah, blah, blah. Okay, that's number one. No discretionary authority. And number two, let's meet a couple times a year. Wouldn't it stand to reason if we're supposed to meet our dentist once a year? Wouldn't we want to meet with somebody who has some kind of impact on the growth of these assets a couple times a year? And the answer is yes. In fact, that's a prerequisite before we do business. And I'm not tooting my horn. I'm just saying that's what you probably ought to find. And that is somebody that says, we need to sit down and look at what we're doing, because if the bucket is falling faster than it is filling up and maintaining, then we need to know this. And we don't need to be 1 year, 2 year, 3 years down the road to make those changes. You need to know along the way.
So the investor meets with the trustee and the corporate trustee.
That's right. That's right. And normally the corporate trustee, and by the way, Mass Mutual has a trust department, and I'm going to pitch it because I work intimately with them. But you go to Broadway Bank, they have a trust department, and they're the ones that will build a portfolio that, again, is commensurate with your risk tolerance and your goals.
Thank you.
So we're right at the 2 o'clock mark. I just want to, I know we still have a lot to cover. Sheila, are we okay on time? And Jeff, I want to be respectful of your time too. I know we had said we'd go till 2. Are we able to stay on a little bit longer?
Oh,
We are. We don't, our next meeting's not until 3.
Okay, Jeff, I want to be respectful. This is all great. And I think the conversation, it's wonderful that we can have that, if we can keep it going, if possible. But again, want to be mindful of your time. Is that okay for us to continue? Okay.
I'm totally okay with it. I am going to kind of move through these slides. We've talked a lot about a lot of what I'm about to move through. And again, if anybody wants to send me an email, I can send this entire presentation to you. To you, Ashley, of course, but to any of the other families that may be listening.
Okay, great. Thank you.
Yeah. This is just the first party. First party trust is a payback trust as well. That just simply means that at the death of the beneficiary, the state is reimbursed for all Medicaid benefits paid to or for the beneficiary. So remember, a first party is a trust that is funded with the beneficiary's money. Head injury, car accident, there was someone found at fault, there was a settlement, $1 million lands in this person's estate, and that $1 million goes into a first party trust. Those assets can be used to supplement his needs, right? But at his death, anything that has been provided to him by the way of Medicaid has to be paid back before his brother, who is the secondary beneficiary, receives the remaining amount. Okay, that's the biggest thing about the first party trust. Let's see. Third party special needs trust, we talked about that. The trust provides for a remainder beneficiary. So anything that goes into a trust for the benefit of Tommy, okay? When Tommy dies, if there's any assets in the account, then in a third party trust, it can go directly to Tommy's sister, Terry, right? In a first party trust, before it goes to Terry, it has to pay back Medicaid. Because again, remember, this is the money in the first party trust, in the first party Medicaid payback trust. This is his money that he received, but he's getting benefits from public assistance, right? And remember, the premise that I discussed earlier was the government will only help us when we can't help ourselves. Well, if we have more than $2,000, the government says you can help yourself. So if a first party Medicaid trust just says that that individual received $1 million as a inheritance or a payment of some sort, we're still going to take care of him. But when he dies, the money that's left in that trust, if there is any, will be used to pay back Medicaid. Let's see. Here are some ways of funding third-party trust. Again, money that's coming from an outside source, lump sum payments, annual payments, life insurance. Sometimes there will be estates that will say, we want to, for the purpose of estate planning, they want to give away money to their children. And that's where the annual payments is referring to, is that they will give money away to the trust as an annual payment. Lump sum payments sometimes happens. Guys, in 11 years of working almost exclusively with special needs families, I can tell you that 95% of all trusts have been funded with life insurance, because you can pay a premium for a life insurance today on Thursday and die tomorrow, and $1 million can be in the trust by next week. It is that amazing how that works. Okay. So life insurance is just generally the easiest way for that funding of the trust to take place. All right, there's some discussions about the corporate trustee. Their relationship manager is resigned, blah, blah, blah. Here's some, I won't go through this. I thought this was kind of fun. Ma'am, you said something earlier, and I wish I could see your name, in terms of what our role is as a fiduciary on the funds, because there's a tremendous amount of trust that has to be placed. But Judge Daniel Putnam, back in the mid-1800s, said the fundamental principle for a fiduciary, and I can't read that because my screen is of the little picture there. Well, crap.
I heard that that's Mary.
Okay, well, okay. No, I'm just saying that I can't read it because I can't find my cursor. But those with responsibility to invest money for others should act with prudence, discretion, intelligence, and regard for the safety of capital as well as income. And so all those are words. It doesn't really put any pressure on me on a day-to-day basis. But the reality of it is, when you find an investment advisor, when you find a financial planner, when you find a special care financial planner, guys, it is very, very, very seldom about what this individual knows, right? So Jeff, if it isn't what they know, what does matter? And I say almost 100% of the time, it's about the relationship that you have with this person. I was a high school science teacher back in the day. I taught and coached for 10 years. And one time I walked in, my mother was still alive, mom and dad. And I said, Mom, I don't think I'm a good teacher. And she said, why do you say that? And I said, well, I just don't know. I mean, I think I am. And she said, Jeff, just remember this, that education is not about what you know. It's about relationships. And then I had an advisor tell me one time, he said, people don't care how much you know until they know how much you care. Well, that's what you should be striving for, is you're looking for somebody to help you address some of these issues. And that is, do they know our story? Do they know what our goal is? And then hold them accountable for what it is that they've promised to do. All right. All right. I'm going to move very quickly through ABLE account. Overview 2014, President Barack Obama signed the ABLE, Achieving a Better Life Experience, or ABLE Act, as a part of the Tax Increase Prevention Act of 2014. There is an account that you can open up for a child called a 529 account. And a 529 account is used for qualified educational expenses. So I have mothers and dads come to me and say all the time, Jeff, I want to start putting money away for my child's education cost. And we will use a 529 account. And that just simply means that money going into the 529 account grows tax-free when pulled out for the purpose of buying books and paying tuition and materials, et cetera, et cetera. Well, in 2014, President Obama said, you know what? There's a huge cry for the special needs community that led to the creation of the 529A or ABLE account. And it just simply means that money going in to the ABLE account can be used for the purchases from a special needs individual, and it does not disqualify them for meeting that $2,000 limit, right? So we kind of established that before. They had this $2,000 threshold you don't want to exceed. Well, a person can have an ABLE account with $100,000 in it, and it does not disqualify them from public assistance and that $2,000 threshold. All right. Eligibility requirements: you must be blind or disabled prior to the age of 26. You can be older than 26 when opening an account as long as the disability occurred prior to 26. Account limits: you can only put $15,000 in a year, and currently the maximum amount is $100,000. So once you get to $100,000, like that, I always laugh at that. You can only get $100,000 in it, and I go, hey, there are not a lot of people that are getting $100,000 in their ABLE accounts. That being said, I had a lady one time, and I think it was a grandmother or grandfather sitting in the audience. And the grandmother, as I was going through this, she just kind of mumbled out loud and said, the best thing I ever did. And I stopped and I said, can you please share what you're talking about? And she said, opening up an account, an ABLE account for our grandson was the best thing we ever did. And the short of the story is that she had a grandson who did have the mental capacity to act on his behalf, albeit somewhat abbreviated, right? And the ABLE account gave that individual some level of independence that he would have otherwise not had. So there are qualified expenses that the ABLE account can purchase, all right? And I challenge you, without going through that lengthy list, just search, what can an ABLE account pay for? It's a lot. So right there, qualified disability expenses. An ABLE account can be used to fund education, housing, transportation, employment, health, prevention and wellness, legal fees, funeral, burial, and basic living expenses. So there's a lot of things. And that's not a very fun list right there, but it is very comprehensive, okay? And so ABLE account payback requires a Medicaid payback to the states when the beneficiary dies. So if your child or if Tommy's receiving Medicaid, right? Remember, Medicaid is kind of the indigent level benefit, right? You have to be indigent level below 2,000 before we receive, well, not all the time, obviously, but we have a $2,000 stipulation. If we are receiving Medicaid benefits at the death of the account holder, right? Tommy owns the ABLE account, right? And by the way, Tommy can fund the ABLE account, mother can fund the ABLE account, grandparents can fund it, best friends, neighbors, et cetera. Anyone can fund the ABLE account. It's owned by Tommy, right? Well, that gives you some idea of what Tommy's capacity has to be before we open up an account on his behalf. But at Tommy's death, anything that was provided to him in the form of Medicaid benefits has to be paid back from the ABLE account. States decision whether to adopt the ABLE. Suffice it to say, Texas has an ABLE account. Opening an ABLE account, state determines, depending on the state, blah, blah, blah. It's all pretty standard. This right here, take a picture of this slide, right? The ABLE National Resource Center, ablenrc.org. I told Ashley this months ago, and I'm about to wrap up here. I help my clients on a lot of levels, okay? I help them deal with all of these matters. I direct them to the people that can get us the answers. And by the way, that's all I am. I distribute my clients to the people that are highly, highly qualified, like Ashley and Dawn, right? And, but the role that I play as a quarterback says, let me help you put the pieces in place to achieve some of these benefits down the road. Well, the ABLE account, I can help you with the ABLE account, but this is probably your best route to get it achieved. If you let me help you open up an ABLE account, it will cost you, all right? And it's not that complicated. Now, the value that I would bring in helping you open up an ABLE account is I'd be able to give you some professional perspective on the investment management of the assets inside that ABLE account. Do I think it's worth it? Yes, I do. But I also appreciate the fact that we're trying to get in without any cost if we can. And this organization will direct you to state-specific ABLE accounts. And I make myself available to you to kind of help you navigate this. And this sounds counterproductive, I know, but I'm probably not the best resource for you to open up an ABLE account. Again, because this organization can get you to account providers that won't cost you anything, whereas I kind of have to. You see the little halo around my head? Wow.
Yes.
So Jeff, we know you mentioned here in Texas, so it's state specific. It has nothing to do with the city where you live, your county. It's state specific, correct? Okay.
That is correct. And really, I've run into state specific criteria my entire career. And you could you could open up an ABLE account in the state of Ohio if you wanted to. You would just be obligated to follow the rules that have been set forth in the state of Texas. That's why people don't go to Colorado to open up an account if they live in San Antonio. So yeah, you would follow the state specific plan, but there's tons of companies that offer the state of Texas specific plan.
Okay.
And that generally, because you can only put 15,000 a year in, there's a maximum of 100,000. So whatever 100,000 divided by 15, 6.5 years. If you're putting the maximum in, it'd take you 6 or 7 years to get it in there. But yeah, it is state specific, and this resource will get you to where you can get it set up. And I encourage it. Now, look, here's, let's see.
Well, I saw something there about 26. So there's an age, right? You mentioned that age. It was
Right.
back on another slide, right? So 26, they can't be created after the age of 26.
That's right. That's right.
Okay.
Unless the disability preceded age 26.
Got it.
I want to show you one more slide here. Not that one. Okay, I was just going to tell you that there are probably, if your dependent is incapable of representing themselves, then the ABLE account is not a very useful tool for you. Okay, so it is limited in the extent that the dependent has to be able to represent him or herself. And I actually don't know what the criteria is where that is achieved or not. And I suspect that the individual account providers, there would be some kind of vetting system which would help you to determine whether or not that's a valid opportunity for you or not. So keep in mind that the ABLE account is funded with after-tax dollars. right? So we all get we get paid, right? And we pay taxes on what we get paid. Well, the money that goes into the account is money that's going to be considered part of our taxable income at the end of the year, right? But with the money that we put into the ABLE account, assuming it's growing because it's being managed properly, right? It went from 10,000 to 13,000. So you had $3,000 worth of growth. Well, if it was just in a normal brokerage account and you took some money out, you would pay 15% capital gains tax on those earnings. If that 10,000 grows to 13,000 inside of an ABLE account, you take money out, that money is not taxed if used for qualified disability expenses. Okay, so that's the value of the ABLE account for a candidate who is, again, capable and eligible to represent him or herself. All right, take a picture of that. If you would like to visit with me, if you have any specific questions